Mr. Anstedig, what case are you on?
Judge, I'm here on Homesite versus Tittle Brothers. I believe
I have the other side.
It's me, Mr. Gutner, Your Honor.
Correct. So I'll go ahead and call that case Homesite versus Tittle Brothers. This is set for a pretrial today. Have you gentlemen had an opportunity to speak to each other?
we've had a couple of different conversations, Your Honor, and I have, with some difficulty, submitted my documentation and proofs to Mr. Guntner for him to review with his client to see if we can't work towards resolving this. I have not heard from Mr. Guntner since I did send the documentation. And that's kind of where I'm at.
Mr. Guntner, what?
Yeah.
Or Mr. Barbie, is it Barbie? It's Barbie, correct?
No. Barbie is Greg Barbie, and I'm Patrick Guntner.
Oh, got it. It's the law firm. Got it. Okay.
This is what happens when your office set up the Zoom ID. You know?
Yeah, no, I get it.
So that's who we are. Although I've been called worse than Mr. Barbie at times, I'm sure. You know what? Opposing counsel's right. We have had some conversations in this matter. You know, we have a little bit of a disagreement as to the amount of damages and why. All I would ask for at this point is a scheduling order, giving us a little time for discovery. I did submit the documents that were given to me by the plaintiff's counsel to my client. Again, I'll have a conversation with him about that. But if you just want to give us a scheduling order with some discovery time, I look forward to the opportunity to try to resolve it with him if we can.
Okay. Hang on one second. I'm trying to I just realized I don't have a copy of my docket for adjournment. So so let me see if I can get them. I have, so how much time do you just want an adjourned pre-trial? I mean, what do you need in this?
Yeah, I'll take an adjourned pre-trial or a scheduling order. If you're going to do discovery, Your Honor, 60 days would be fine for counsel. Now, he's already gotten me some of his documents. So whatever works for you that you can get done, I'll leave it to your preference.
Well, I can give you, I can just open it for discovery and give you 60 days and put it to May the 18th at 10 o'clock.
For an adjourned pretrial, Judge?
Correct. So I'll adjourn it for discovery 60 days.
Okay.
And do a pretrial May the 18th at 10 o'clock.
All right.
Does that work?
On behalf of Tittle Brothers, yeah, that's fine, Your Honor. Thank you so much.
Mr. Aniston, okay.
Yeah, thank you.
And write that down before I get my docket thing so I don't set too many things. All right, then you're all set for today. Thank you.
Thanks so much, Your Honor.
Yep. Have a great day.
You too, Judge.
We have Miss Clement joining us. So as soon as she's on, Mr. Groen, that's you, correct?
I'm here on
but
the...
she has Mr. Evanchek too.
Yeah.
Though. Yeah. And I don't see him on yet. Gentleman on the iPhone, what's your last name?
Your Honor, this is Hal Burke.
Thank you. You're welcome. Thanks a lot.
You're welcome.
What case are you on?
It's set for 9:45 Beaumont versus Gregory. I got a note that said he'd like us to be on early.
As soon as I get Mr. Evanchek, who I apparently am waiting on another case also. I've got it. I'll pull it.
Thank you.
And as soon as Mr. Evancheck gets on, we'll do it.
Thank you.
And then, Miss Nonis, what case are you on?
I have Jefferson Capital Systems versus Boyd, which is 204148.
I have it, Nancy Boyd. Yep, I have it. We're just waiting on Miss Boyd. Mr. Sapersky, what case are you on?
Good morning, Your Honor. William Beaumont Hospital v. a Shaquille Anwar.
Okay, I'll pull it. We're just waiting on, is it Mr. Anwar?
Yes,
Perfect. And then
Thank
Miss
you.
Clement, can you hear me?
I can.
I have you checked in. We're just waiting for Mr. Evancheck for your attorney, okay?
All right, thank you.
You're welcome. So I guess everybody just hang out for a minute. Mr. Lewis, I think we got, somehow you guys got lost, Miss Nonis.
Uh-oh.
Oh, no. Never mind. I'm waiting from Kara Bailey. Sorry about that. Wrong person. Good morning, Mr. Evanchek. You on?
I am now, Your Honor. I'm not sure what was going on.
Yeah, I
Um,
have a couple cases with you. I think the first one was the LVNV funding versus Christina Clement.
Yeah, I didn't have a chance to talk to opposing counsel before the hearing this morning, but I think I just got an email from him asking me where I was.
Yep.
So I'll probably, yeah, if you don't mind, I'll give him a call, hopefully. Brian, are you available after the hearing?
I have another hearing after this one with Judge Green, so
Oh,
But
so do I. I got one at 9:45, so,
I
And
I have a
that one's
10.
already ready too. Well, what's the status of this case right now?
I was gonna make an offer to resolve it to counsel, so hopefully we can get it negotiated away.
Do you
Your
want me
Honor,
to give you?
Yeah,
ahead.
I was just gonna say, if you can just give us an adjourned pretrial date, I'm pretty confident that we can get this one squared away.
Yeah.
How about April 27th at 10:15?
That's a little bit too far out, Your Honor.
I've
don't
got
wanna-
it April 6th at 10:15.
Do you got anything like a week or two out?
No, I don't. I've
Okay.
got a full docket, a murder case that's coming up.
Oh.
Nope, the next date I have is April the 6th
And
All
what
right,
time
give
is
us
that,
the
Your
six,
Honor?
but that's fine.
at 10:15.
That
Okay.
should work. That should work for me, Your Honor.
Yep, same here, Your Honor. All right, it's 4, 6, and 10.
At
Okay.
10:15, and hopefully it's resolved and I don't see you guys then.
That
Yeah,
sounds good to us.
Same
All
here,
right,
Your Honor. Thank you.
Miss Clement, you understand?
Yes, thank you.
All right, you're all set for today. Thank you.
Thank you. Me.
All right, Mr. Evanchek, on your other case, which was Beaumont
both.
Hospital versus Michelle Gregory. And we have
Yes.
Mr. Burke on.
Yes, Your Honor.
Yeah, yes, Your Honor. If the court recalls, the court adjourned this so that counsel could serve me with a copy of the sums of complaint. I don't think they retained copies, it sounds like. I'd emailed them last week to just have them regenerate it. We'll treat it like an amended complaint, but I don't think I've gotten it as of yet.
Mr. Burke?
Your Honor, we show sending it to him on Monday. If he did not receive it, I can resend the email. Either way, I think we're.
You
close to
emailed it?
resolve-
Yeah, let me take a look. I might have just missed it in my email. No, I don't see, last email I got from you guys was on 3/3.
I sent it myself yesterday, but I will resend it
Yeah,
today.
if you could, let me look in spam because sometimes it goes there. I don't see it there. Yeah, if you could resend it, I'd be greatly appreciated.
Okay.
So with that being said, then do you need a couple, is that April 6th date good for you then too, also at 10:15?
Yeah, that's fine, Your Honor.
Council, is that good for you?
Yes, Your Honor.
So we'll do the adjourn to April the 6th at 10:15.
Okay, so we're gonna, the other one's
We'll
at
do
10.
both of them that day.
Okay,
Do
all
you
right, that's fine.
understand? Miss Gregory, your attorney will be in contact with you then, okay?
Okay,
And if it's not resolved, we'll see you April the 6th, same place, okay?
okay, sounds good.
All right, you're all set. Thank you very much. Have a
Thank
great
you.
day.
Have a great
Jefferson Capital versus Jacob Lewis.
Morning, Your Honor. Kara Bailey, P73071 on behalf of the plaintiff.
And you had a breakout room with Mr. Lewis.
We resolved it, but I'll tell you, when I tried to leave,
It's okay.
air and stuff, and I had to re-sign in. So I'm
So
not
did
gonna
he.
fault Mr. Lewis if he hasn't come back.
Oh, yeah, no, he's back, but he's trying to join his audio. I think maybe he got it now. Mr. Lewis, my understanding is that you guys resolved it. You got to unmute, lower left, probably.
Yep. Yes, I'm sorry.
You're good. Yeah, I don't know what happened with the breakout room, but we're good. I think part of it is my computer because this computer has not been updated and I had a hard time getting on Zoom this morning. And then I was like, uh-oh, should have updated it. So when I'm done with my docket today, or I have a time frame, I'm going to update it. And so hopefully that it'll get rid of some of these glitches I'm having this morning. So do you want to just, I'm just going to write that you're going to submit a consent?
Yeah, so you want me to mail it to Mr. Lewis and have him sign it? Rather than do
Actually,
it under the
Mr.
7
Lewis,
day?
can she sign for you?
Yes, that's fine.
Mm-hmm.
So you can sign his name. You want to put on a record what the terms are, and then you can just submit it.
Yep, I'll put on here that he agreed on the record. All right, so we sued for, it's gonna be a consent judgment for a total amount of $807, which includes $627.56 in principal damages, $55 filing fee, and $49.44 in service costs, as well as a statutory $75 attorney fee. So that does come to a total of $807. He's gonna pay it in installments of $100 a month on the 15th of each month, starting April 15th of this year.
Okay, perfect. Is that your understanding?
That is correct.
All right, then, you are all set, okay?
All right, we'll mail a copy into the court for your signature, Your Honor.
Perfect. All right, thank you very much. And
You
then,
guys have a good day.
you too. Jefferson Capital versus Nancy Boyd.
I'm ready, Your Honor. Is defendant here?
She is not, but if you want to, you can go ahead and take the default. It was set at, oh, I take that back. I apologize. I thought it was set at 9:15. It wasn't. It was set at 9:30.
Okay.
So just hang out for a few more. William Beaumont Hospital versus Shaquille Anwar.
Good morning, Your Honor. Joe Sapersky on behalf of Beaumont Hospital.
Good morning. Mr. Anwar, can you hear me?
Yes, I can. I'm here. Hello.
Okay, perfect. Have you had a conversation with Mr. Anwar?
No, I have not.
Do you want me to put you in a breakout room?
Sure.
All right, I will do that. Hang on just a sec.
Sounds like there's been issues, so if I'm not back in a little bit, I'll
Yeah,
dial
you
back
can just
in.
log out and log
Okay.
back in. Yeah,
All right.
hopefully it was user error.
Okay.
Mr. Bass, what case are you here on?
Good morning, Your Honor. On Tracer versus Brandon Morris. Motion for SD at 10 o'clock.
I see that. I'm pulling it. And the other side is Mr. Morris. He's not on yet. So we'll wait for him. Mr. Roshan, what case are you on?
I am on Hal Burke, Beaumont Health.
Oh, I see Beaumont Health versus Harold Roshan. I see it at 10:15. You're a few minutes early, but you can just wait and I'll pull the file. And as soon as Mr. Burke, you're still here, aren't you? No. He said that he had he was here this morning, so he must be signing back in. As soon as we get him back, we'll do your case, okay?
Thank you.
Yep, so just hang out and wait. Are we ready on William Beaumont versus Shaquille Anwar?
We are, Your Honor. We just had a chance to speak, and there's a difference in the numbers of what my client says Mr. Anwar owes and what he thinks he does. I've got the complete itemization of the services and then the insurance payments. I'm going to forward to him a copy today so he's able to look at exactly what I'm looking at, and that way we'll be able to have a chance to speak.
Okay, do you want me to adjourn it to April the 6th?
Sure.
10:15? Does that work for you, Mr. Anwar?
Yes, that's fine.
All right, then if you resolve it before then, let us know. Otherwise, we'll see you on the 6th at 10:15, okay?
Sounds good. Thank you, Your Honor.
Perfect, thanks. Have a great day. Sir, what case are you here on?
Are you talking to me?
I am.
Actually, I'm part of the case with Weeks, Elizabeth Weeks.
Portfolio recovery?
Yes, I believe.
And who are you?
My name is David Paris. This is a long involved story. Elizabeth is a disabled adult.
Okay, okay. Well, let's wait for the attorneys and are you her conservator or guardian?
No, I have her mother and her sister here. I'm just getting on to the meeting.
Oh, okay, okay, that's fine. There are two attorneys, so we're just waiting for the attorneys, okay?
Okay.
Okay, thanks. So go ahead and mute yourself, please.
How do I do that? Oh, never mind. I found it.
Your Honor,
Yes.
I just want to make sure you have me checked in for my next hearing. I have a 10 o'clock with the Citibank Pamela White matter.
Yeah, what else are you on?
I'm here on that one, and I'm also scheduled for 11:30, but I do not see that one on the court docket. So
Okay, I pulled Citibank, so I got it.
Okay.
And then you said you have an 11:30?
But it's not appearing on the docket. It was one that it was held last month, and then I guess the defendant showed up later. So we got a call from the clerk saying it was going to be rescheduled to today at 11:30, but I'm not seeing it listed.
What's the case name?
Case name, or do you want the case number?
It doesn't matter. Give me either.
Okay, well, it's another Citibank. So it's Citibank, and the defendant's name is Clyde Franklin.
Clive, C-L-I-V-E?
C-L-Y-D-E, and then
Okay.
Franklin.
Franklin, yeah. We're gonna look, because it's not on
Okay.
my docket and I
Yeah.
don't have the file. It's a Citibank case, Michelle.
It's
She's
20.
calling-
Okay,
She's calling over to check.
perfect. I appreciate it, Your Honor.
Yep, no problem. Mr. Canine, what case are you on?
Good morning, Your Honor. Crown Asset versus Reed.
I got it, I'll pull it,
Thank you.
and we'll wait on Miss Reed.
Thank you, Your Honor.
Mr. Mr. Groen, I just found out that it's not set for anything. They're holding it. You sent in a 7-day order, so they're waiting. If there's no objection, they're just gonna enter it.
Oh, okay, that's perfect. That
All
saves
right.
me at least, yeah, I agree.
Yep.
I appreciate that.
Mm-hmm. Good morning, Mr. Johnson. What case are you on? Oh, he's connecting. Miss Nonis. It is after 10 o'clock. Calling Jefferson Capital versus Nancy Boyd.
Good morning, Your Honor. Attorney Ashley Notice on behalf of plaintiff.
The defendant has failed to appear. It was set at 9:30. It's now after 10 o'clock. You can submit a default and I'll sign it.
Great. Thank you, Your Honor. I'll send it in. Have a great day.
You're welcome. You too. Mr. Johnson, what case are you on?
Pinewood Circle.
Pinewood Circle versus Dietz Johnson. I pulled it and I've got it. We're just waiting on Mr. Katz.
Okay.
So just hang out.
All right.
I apologize, Mr. Johnson. You are actually all set. We received a dismissal on this file this morning, so it's dismissed, okay?
Okay, cause
Is
I was
that-
about to say, I paid the money off.
Yep, I see that, and they sent in a dismissal this morning, okay?
Okay, then you have a nice day.
You too, have a great day. Mr. Trahey, what case are you on? You're muted.
Okay, sorry about that. Just I'm on. I'm looking for the plaintiff's name. The defendant is Elizabeth Weeks.
Okay, I actually think I have on portfolio discovery. Do I have the plaintiff's attorney? I got him in 1 second. Portfolio recovery versus Elizabeth Weeks.
That is correct, yes.
Yeah, no, oh, you know who I have on? Mr. Roshan, who must be Miss Weeks. The family is on here because they indicated that she's disabled or.
That is correct.
Do you want to break out with the family?
No, I don't need to do that.
Okay, well then just hang out and we'll wait. We're waiting on the plaintiff's attorney.
Very good. Thank you, Judge.
All right, thanks. Okay, Mr. Burke, what's the case that you're on? I know that
Yes, Your Honor, I thought I was on mute. I have 1015 Beaumont Health versus Harold Roshan.
yeah, oh, yep, we got that. On Beaumont Health versus Harold Roshan. Oh, you know what? I was mistaken on Mr. Trahey on the person that was the family for your defendant, but sorry about that. And Mr. Roshan, can you hear me?
Yes, ma'am, I can hear you.
Have you had an opportunity to speak to Mr. Roshan?
I have not, Your Honor. Would you consider allowing us to go into a breakout room?
Absolutely. I'll put you in one right now.
Thank you.
All you have to do, Mr. Roshan, is hit join. And Mr. Is it Bedouin? Good morning. What case are you on?
Jefferson Capital versus Sadler.
Okay. I have that. I don't have Mr. Sadler, but it's set at 10:15. And then did I have somebody else that just joined us? Nope, apparently not. So just hang out, and I give him a half-hour window.
Sounds good, Your Honor.
Mm-hmm. Good morning, Mr. Krikorian. What case are you on?
Good morning, Your Honor. Mike Corcoran. I'm here on the Annette Holdings, Inc. versus Area Towing Recovery. We have a summary disposition motion and
At 10:30.
yeah.
Yep. Who's the attorney on the other side that we're waiting on?
Mr. Roderick Fracassa from Plunkett Cooney.
And you represent, who do you represent?
I represent Area Towing and Recovery.
Okay, got it. All right, as soon as they jump on, we'll do the case.
Thanks. No problem.
Yep. Good morning, Mr. Werber. What case are you on?
Good morning. I am here on Portfolio Recovery versus Elizabeth Weeks.
Perfect. We have Mr. Trahey and we actually have the family of Miss Weeks. So I'll go ahead and call it Portfolio Recovery versus Elizabeth Weeks.
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
Good morning, Your Honor. Stephen Trahey, attorney for defendants.
And if you had the opportunity to speak to each other?
We have not.
No.
Do you want me to put you in a breakout room?
I do request that, yes.
Do you want me to put the family members in there with you or no?
I don't think that's a good idea at this point.
Okay, I don't know what the dynamics is, so I just wanted to check. All right, Mr. Werber, I'm going to assign you to room number 2, and Mr. Trahey, go ahead and hit join.
Thanks, Your Honor.
Are you ready, Mr. Trahey?
Yeah, yes, we are.
Portfolio recovery versus Elizabeth Weeks.
Your Honor, we did have the opportunity to discuss this matter. The defendant has numerous files with portfolio recovery. Apparently, there was a fraud or the father forged her name and opened up these cards in her name. I'll take all the information Mr. Trahey provided back to my client, see how they want to proceed. And I told Mr. Trahey I'd give him a call by the end of the week. If you just want to put a scheduling order out there, we're not going to proceed with any type of motion for the time being.
Well, can I give you, is a month a good time frame? If I adjourn it to April the 6th at 10:30, that should be sufficient time
I think
for
so.
you guys to.
That's fine.
Yeah,
All right, we'll do it April the 6th at 10:30.
sounds great. Thanks for your
All
time, Your
right.
Honor.
Okay, thank you very much. Have a great day.
You too. I'll talk to you soon, Mr. Trahey.
The person that's identifier is Dave, which I think is the family members. Do you understand? And Mr. Trahey, he'll be in touch with you.
Yeah. Yes, Your Honor.
Okay, perfect. All right, thank you very much. Have a great day.
Thank you.
And then Mr. Burke on Beaumont versus Harold Roshan.
Yes, Your Honor. Thank you for allowing us to go into the breakout room. We had a productive conversation, and I'll make this my request, although I know it helps Mr. Roshan. He is going to contact his insurance. He's a former employee of the city of Detroit. And he believes I know you've been offering April 6th as a date. He believes well before then, he'll have an answer as to why his insurance did or did not pay this, and knows that we're only trying to get paid once on this bill. And again, we had a very cordial conversation. I think once he gets that answer, that will assist the case.
So is April the 6th at 10:30 work for you?
It does for the plaintiff, Your Honor.
Mr. Roshan, is that okay with you that I'll adjourn it to April 6th and hopefully you guys will be able to figure it out between now and then?
Yes, ma'am.
Perfect. And if you don't work it out, well, I'll see you then and then we'll go from there, okay?
Okay, thank you. About the same time, well, I'm sure we'll work it out.
It's going to be
before then, but-
10:30. Yep, April the 6th
Okay.
at 10:30. Same place, so same Zoom.
Okay.
All
Thank you.
right? Okay, you're welcome. Have a good day.
Have a great
you.
day.
All right, you too.
Thanks. Ms. Johnson, what case are you on? You're muted, lower left. You got to unmute yourself.
Sorry, I thought I already had done that.
That's okay.
Good morning. I actually have two cases this morning, 203311 GC and 204400 GC.
What are give me the names.
Um,
Oh, I see William Beaumont is the one. Okay, and portfolio recovery is the other. They're
Yes.
set at 10:45, so you're a little bit early, but I'll pull the files, okay? And as soon as the attorney jumps on, we'll do it, okay?
Okay, thank you so much.
Thank you.
You're welcome.
Mr. Fracassi, give me just a second. I checked you in and I'll be with you in just a minute.
Okay.
All right, good morning on Annette Holdings versus Area Towing.
Good morning, Your Honor. Mike Corcoran on behalf of Area Towing, and we're the moving party this morning.
Good morning, Your Honor. Rod Picasso on behalf of Annette Holdings doing business as TMC Transportation.
And this file is super thick and it's set for a motion for counter plaintiff's reply. Yeah, it's set for a motion for summary this morning.
Correct.
And I have everybody's motions and reply briefs. And counsel, if it's your motion, go ahead.
Okay, Your Honor. I'll try to be brief. I know you had some recollection of this case. So Area Towing provides towing and recovery for the Michigan State Police along the I-94 corridor, among other places. Defendant was the registered owner of a 2016 Peterbilt semi-tractor and a trailer. On November 1 of 18, the vehicles were involved in a single vehicle accident on I-94 in Taylor. Michigan State Police called my client to the scene for the purpose of towing and recovery. That's all set forth in the affidavit of Shane Anders, who's the owner of my client's entity. There's a crash report attached as Exhibit 2. It's clear that the damage to the vehicle was disabling.
I don't think that's in dispute, is it, Mr.
Yeah.
Fracassi?
No, Your Honor.
Well,
I don't think so.
The reason why I bring it up, Your Honor, is Mr. Fracassi keeps trying to suggest that this vehicle wasn't a quote unquote abandoned vehicle. But the abandonment.
It was incapacitated, whether it was
Right.
abandoned. Abandoned may have a different definition than incapacitated. It couldn't have been driven away.
Correct. All right. So right after the crash, my client allowed them to come get the wood and the other materials that spilled all over I-94 that they had to collect. A week later, they were able to come get their stuff. My client then provided a detailed invoice to the plaintiff counter defendant. And rather than trying to negotiate that or any communications in December, a month later, they filed a lawsuit in circuit court. And they claimed under claim and delivery, conversion, etc. The court may recall that I filed a motion to dismiss and or to remand.
Right.
Murphy agreed that it should be remanded. We fully expected that the plaintiff would then file an actual petition under the abandonment statute, since the abandonment statute has exclusive jurisdiction over this matter.
Wait, let me ask you a question about that. There's never been a TR 52.
Yes, there was. So what happened is that after the circuit court case was filed, my client requested that the state of police abandon the vehicle.
Right.
And on January 22nd, which is the Exhibit 3 on my brief,
yeah,
a TR 52 was issued, and then the TMC attempted to file a petition for abandonment with this court or a district court, the applicable district court at that time.
Right.
On February 11th. Now, I know I only went to MSU and I didn't study math, but that's 21 days. And the statute says you got to file it within 20.
Right.
So that not only, I mean, it was rejected for other reasons, but they were a day late and $1 short. And so the thrust of my brief here, Your Honor, today is, number one is, after we went back before you, the court, this court fully dismissed all the claims. I then sought reconsideration to allow for the counterclaim, my counterclaim under the abandonment statute, to be kept open. And essentially that's all that's before the court is my counterclaim.
Right.
So the gist of it is, and I'm not going to read the whole brief, but when you look at the first issue, is clearly it was an abandoned vehicle. And the reason why, if you look at the definition of abandoned vehicles there, we fit. I don't know what Mr. Ficasa is trying to argue, the Webster dictionary of abandonment. It doesn't apply here. The statute is very clear. Number two is that under 257-252I1, we're allowed to go ahead and bring this counterclaim, which we did. Now, normally we bring these counterclaims after we've auctioned off the vehicle. It's for the deficiency. In this case was unique because the bond, which was actually filed under the claim and delivery statute, was released, and my client did allow them to come get the rigs anyway. So we basically, because we knew this company was a Detroit company and they were collectible.
Sure.
But it doesn't preclude us from bringing the counterclaim. And my point on that is, once they've blown the time statute, their exclusive remedy under the abandonment statute, when they don't like the amount of the fees for recovery and storage, is to file that petition within 20 days of the TR 52. They didn't do that. Once they blow that, they lose the right to object to the reasonableness of the towing and recovery. In fact, 257-252A7 is clear that if the owner does not request a hearing under subsection 6, the only remedy he may have is to obtain the release of the vehicle is by paying the $40 and the accrued towing and storage fees. And so there is no other claim here that they can bring as the reasonableness of the fees. I think our argument is they've lost that right, essentially.
What's the total amount? What's the total amount?
Roughly $39,000 is the two, actually, the total fee was $43,118.62, and that's for towing, recovery, and cleanup. And that was the detailed invoice, I think, is also attached to our brief. It is Exhibit 4. So I just, the argument that, number one, they get to argue reasonableness now when they didn't challenge the order for reconsideration. They didn't come in and try to file a late petition.
Well, let me ask you a question. How do you, what points, I'm trying to figure out my jurisdiction.
Sure.
Because clearly $43,000 exceeds my jurisdiction.
Well, Your Honor, my partner and I, we handle these matters for the Michigan Towing Association members all over the state. This statute is exclusive. It does not have a cap. It does not affect your ability to, I've had $100,000 cases under the abandonment statute in district.
Because it's exclusive jurisdiction. I get it.
Right.
Okay.
Similar to a lease scenario or a landlord-tenant scenario.
I just don't usually get numbers this big on a TR 52. Yeah, no,
Yeah.
I get it.
Yeah, I understand. So the thrust of it is, and I don't normally argue that folks have filed frivolous pleadings, but this argument, these two arguments that Mr. Ficasa is raising literally are not based in law or in fact. We believe we're entitled to a summary disposition as a matter of law because we don't believe they're entitled to now argue over the reasonableness of these fees. The vehicle was clearly abandoned. I don't even understand that argument at this point, that somehow it wasn't an abandoned vehicle. It was under all indicators. So we simply asked the court to grant the summary disposition pursuant to MCRs 2116C8 and C10.
Mr. Ficasa?
Yes, Your Honor.
Response?
Yes, Your Honor. So this has, as you are aware by simply the voluminous pages in the file, this has been an issue that's been ongoing for over 2 years.
Right.
attorney for area towing, concedes in his brief that that they commenced the abandonment proceedings after we've already filed in circuit court. The judge then sent it back to district court. At the district court level, the judge allowed us to entered an order to allow us to recover our equipment. We did file a petition. We have been trying to have plaintiff or area towing negotiate this from day one. Our people showed up at their yard the day after the accident trying to, recover our equipment. The only reason why we filed in circuit court is because of the amount of the damages and the fact that they weren't willing to even negotiate a penny off of their initial demand. The other thing, Your Honor, is initially plaintiff or area towing, they submitted 3 invoices for their towing charges. They issued an invoice for the tractor, an invoice for the trailer, and an invoice for the cleanup. So there was a separate invoice that had nothing to do with towing charges and could not be construed as part of the abandonment claim of theirs. Your Honor, we did file a petition for a hearing. We have presented numerous types of invoices and samples, both to you and to the attorney for area towing. We're trying to resolve this. We attended mediation in good faith where we were negotiating against ourselves for 2 hours because they never even made a counteroffer. And now they're filing this motion for summary disposition. I just want a hearing so we can resolve this once and for all on their invoices.
So let me jump back to the invoices. You have an invoice for the towing and the recovery, which was the 15th. That I can't read it. It's the invoices.
Your Honor, on our brief, it's Exhibit A.
Yeah.
And there's an invoice for.
Oh, it is on yours. It's Exhibit A. Hang on.
Sorry.
No. You're good. Okay. So yours, it's the area towing, which is dated November the 1st of 2018, correct?
Correct.
And that's the amount of the $13,579.54. And that includes, storage. Was it out on 11/13 of 18? Is that right?
No,
Your Honor.
It was there actually until after we had a district court hearing, I believe into February, March.
Yeah.
Is when we made arrangements that allow them to come pick it up.
So, Your Honor, on Exhibit A, the third set of invoices, which is marked invoice 183989B as in boy.
Yep.
The vehicle says cargo. And that invoice is for $15,959.54.
I don't see where it says cargo.
Okay. So
It says
under
traffic
description-
control, aero board for, reload and banding of lumber, 2,500. Yeah.
So you go up where it says description, upper left-hand corner.
I got it. I
Okay.
was on page 2. So this is all cleanup related.
Well, there's mostly cleanup. Very little towing is relatively little, the actual towing charge. Then the storage charge I see here on the invoice, it was actually removed on 3/19 of 19. So it was about $8,340 worth of storage.
That was removed.
That's what the storage was accrued at the time they removed it.
what I'm trying to see is, because here's my problem, is that I agree with you that the TR 52 was issued. If you didn't object within the 20 days, I mean, and I've done these cases for years, you got to object within the 20 days. You got to file something, you got to object to the storage and the tow fees and the storage within the 20 days. But I agree with Mr. Fracassi that the other items of the cleanup is not part of a TR 52.
The items related to the cleanup, or you're holding that it's not recovery and it's not part of the abandonment or the TR 52 and abandonment statute?
I don't know that I think that it is. I mean, it specifically talks about what's the language on the TR 52?
I'll find it.
You know, somebody, I could go next door and grab it, but
I'll
somebody
find
pull
it
it.
here. I have it. It's our exhibit 3. It says you may contest that the vehicle vessel was properly deemed abandoned, removed, or reasonableness of the towing and daily storage fees by completing the enclosed petition requesting.
Right, so it specifically deals with the towing and the daily storage fees. It doesn't deal with, or didn't, I don't believe that the statute contemplated, because it doesn't say other issues related to, I mean, it's a problem.
Yeah, there is I will admit that there's an ambiguity in this, in the TR 52 as it relates to the statute. I mean, I could understand the court holding that Mr. Fracassi's client.
I'm gonna have you hold for 1 second, because I want to get rid of a couple other people that are accumulating on my Zoom here.
Okay.
On Tracer Financial versus Brandon Morris.
Yes, good morning, Your Honor. Stuart Best.
It is now almost going on 11 o'clock. This matter was set for a motion for summary disposition at 10 a.m. The defendant has failed to appear. I will grant you, grant your motion by default.
Thank you, Your Honor. For the record, Stuart Best of the firm of Weltman, Weinberg, and Reese on behalf of the plaintiff, Your Honor. Also, we have the per diem on this runs about $1.08 per day, and they were asking for interest on the judgment at the capped amount of 13%. The contract rate was 24%. Would the court like me to present that judgment via the 7-day?
Yes, please.
Okay, I'll 7-day that. Thank you.
You're all set. Citibank versus Pamela White.
Good morning, Your Honor.
And Ms. White has failed to appear this morning. This
Your
matter
Honor?
Yes.
I just had one quick question, because Ms. White originally had an attorney, Nick Balberman, and we did receive his motion for withdrawal. Was that granted at some point in time or not?
It was entered. Yeah, I apologize. I appreciate that.
No, I just wanted to make sure.
So this is a default and you can file it with us, all right?
I appreciate that, Your Honor.
And you're all set.
Thank you.
And Crown Asset versus Deshonda Reed, Mr. Canine.
Yes, Your Honor. David Canine, P61828 for plaintiff.
And this also is a default judgment.
Yes, please. Thank you. May I submit under 7-day rule?
Yes, you can. You're all set.
Thank you, Your Honor. Have a great day.
Yep, you too. And then Jefferson Capital versus Javon Sadler.
Morning, Your Honor. Sean Bodwine on behalf of the plaintiff.
Good morning. Mr. Sadler has also failed to appear this morning. I'm going to grant your motion for summary, which I actually have a copy of, so I'll sign it.
Thank you, Your Honor.
And you're all set.
Thank you.
Okay?
Yes.
And then William Beaumont Hospital versus Teresa Johnson. Oh,
morning,
Miss
Your Honor.
Johnson, I think that those are set at 10:45. I have Miss Richter on. And Miss Richter, are you on both cases? I have two cases.
Your Honor, I'm on portfolio recovery.
Oh, I did say, yeah. The one's William Beaumont and the other one's portfolio recovery. Do you want me to
I'm
put?
not on a William Beaumont case.
No, I get it. She's the same defendant on both, though.
Okay.
You're good. On portfolio recovery, do you need a breakout room with Miss Johnson?
Yes, I think that would be helpful.
Miss Johnson, I'm going to have you in a breakout room. So all you have to do is hit join, okay?
Thank you, Judge.
You're welcome. And Mr. Clarity, what case are you on?
Good morning, Your Honor. I'm appearing on behalf of defendant Jeremy Cady in the case Kuza v. Cady, 210079.
Yeah, I see it. Let me pull it. Hang on.
Mr. Desai is not, although I don't see Mr. Desai in here. And I think the hearing's scheduled for 11 o'clock.
Yeah, I think well, let me finish my other case and then and Mr. Ammerman, what are you on?
Good morning. I'm here on American Express versus Lynette Spina. I'm the attorney for the defendant in that matter.
All right, we're waiting on the other attorney, so just hang out. Let me finish this motion. All right, gentlemen.
Good morning, Your Honor. This is Attorney Jason Brainer on behalf of American Express. I'm on the Ammerman case.
Okay. Do you want me to put you in
I'm
a
here.
breakout room with Mr. Ammerman?
No, I think we're okay. We have a pretty good working relationship, Your Honor. We just would like to get a scheduling order, if that's okay.
Are you doing discovery?
Yes, 60 days, if that's all right, and then a cutoff date for dispositive motions.
I'll give you the 60 days and then I have a date of May 18th at 10 o'clock. Does that work?
For May 18th at 10 o'clock a.m.
For an adjourned pretrial.
That should be okay, Your Honor, from a plaintiff standpoint.
And that works for defendant as well, Your Honor.
All right, I'll list the May 18th, and that's also we'll just do that as a cutoff for motions, and then we could set them and figure it out from there. All right?
Okay, sounds great, Your Honor.
Does that work?
You're welcome. Thank you.
All right, you're welcome. Have a good day.
All right, thank you, too. Take care.
Yeah. All right, sorry about that, counsel. Mr. Sabersky, what are you on?
Good morning, Your Honor. I am on the William Beaumont Hospital matter with Teresa Johnson, who's, I think, in the breakout room with portfolio.
Actually, Miss Richter's back, so she's not. Miss Johnson didn't come back, but.
Did she not come back?
No.
Oh, here she is.
Yeah, okay. Yep. Let me do yours first. Portfolio recovery versus Teresa Johnson. You talked to Miss Johnson?
I did, Your Honor. For the record, Christine Richter, P61525, on behalf of the plaintiff. Your Honor, I had a chance to speak with Miss Johnson. She's indicated that she has retained counsel to file a Chapter 7 bankruptcy, and she's in the final stages of that. So I guess my inclination would be to just ask for an adjournment of this matter to allow her time to complete that so that we don't waste any additional time.
April 27th or May 18th?
April 27th is fine, Your Honor.
I'll do April 27th at 10:15. Is that what you want me to do on Mr. Sapersky on yours too?
Absolutely, that would be fine, Your Honor.
All right, you let your attorney know that these were adjourned April the 27th at 10:15. Okay, Miss Johnson?
Yes, Judge.
All right, you're all set. Thank you.
Have a great day. Thank you, Ms. Johnson.
You too.
Thank you. Bye-bye.
All right, hang on one second, gentlemen. I apologize. And then Mr. Clardy, we're waiting on the attorney for, and I apologize on area towing, but I'd rather knock these easy ones out of the way and give you guys all the time you need than try to rush through it because I feel like I have these other people waiting.
Sure.
So if you bear with me for a few. Mr. Daniel, what case are you on?
McGinnis and Matuska.
And I see Mr. Martone, I think on here too.
Yes, good morning, Your Honor.
Good morning. Melissa McGinnis versus Michelle Matuska. You guys had an opportunity to talk.
During the pre-trial conference, Your Honor, we did have an opportunity to talk, and we had discussed, is it possible to reach any settlement arrangement? And Mr. Daniel and I realized that we were just at an impasse.
This matter is also set for a motion for summary today. I'm in the middle of trying to do another motion. You're gonna have to wait until I'm done with that. So I'm gonna set that to its side for a second. And as soon as I try to knock out a couple of these other ones, and then I'll get back with you, okay?
Okay.
Mr. Desai, what case are you on?
Judge, good morning. I'm on Rakusa v. Cady, and that's Cady, C-A-D-Y. Ray Kuza v. Jeremy Cady.
I have it. Ray Kuza versus Jeremy Cady.
Yes.
And Mr. Clardy's on behalf of Mr. Cady. Have you guys had an opportunity to talk to each other?
Yes, Your Honor. My office has spoken with Mr. Desai.
And what's the status of this case?
I think we might need a trial date, Judge.
Not for me, you don't. I'm gonna have to disqualify on this if it's going to trial. And
Okay.
Mr. Cady is an elected official in one of our communities, and so we'll disqualify probably the entire court.
Oh, goodness. Okay.
Yep. I'm surprised your client didn't inform you of that.
Your Honor, will we be hearing the motion for summary disposition today, or are you going to disqualify yourself on that as well?
No, I'm not. I can't hear. And I'm pretty sure that Judge Oakley and Judge Martin are going to take the same position. So I'm going to make that notation that this is not resolvable, that it needs to be disqualifying. I'll have them let you know by the end of today or tomorrow whether or not Judge Oakley and Judge Martin, and then it'll disqualify to another court.
Thank you, Judge.
All right. Any other questions?
Judge, last question. I hate to bother you with this, but your decision, will your clerk notify us by email or in the letter?
I'll ask her to call your offices.
Excellent. Thank you so much.
Thank you, Your Honor.
Okay.
All right.
Thank you,
You'll
Judge.
hear from us. I'm going to walk the file over when we're done. So you'll hear from us. Okay.
Very good.
Thank you.
Have a good day. Thank you.
You too. And then I think we got rid of everybody except for who's on the Galaxy S20 Ultra.
I'm Cookie May.
Cookie May.
With Midland.
I got it. Midland Funding versus Cookie May. I got it. We don't have the attorney is for Midland Funding yet. Oh, yes, I do. Oh, Mr. Najer. Mr. Najer, Midland Funding versus Cookie May. Do you need a breakout room with Miss May?
Not really, but if you want us to
Okay,
talk-
nope, you don't have to. Go ahead. The last thing I have is noting that the objection to garnishment was valid, but I don't have a date on when that was.
Yeah, I don't know.
Go ahead with your argument, Mr. Najer.
I'm not even sure which kind of garnishment, but I still show a balance in our system. Let me go back to it. The only time we got one payment income tax, but I think that's probably what she's objecting to, $1,064.97. And I still show a balance of
Oh, this is, the
$370.
objection was valid back in September of last year. I don't know what that was about. You know what I mean? This is,
Yeah, I thought, well, right, I'm wondering, did we show up or we didn't show up? Maybe.
I
the
don't know.
clerk
You
said-
probably didn't appear. Is this
Yeah,
a
that's-
tax garn? Miss May, is this a tax garnishment?
Yes.
Okay, and what's your objection?
My objection is that I resolved this in 2007. And I resolved it by paying what they asked for at the time, which was a discounted rate. And they're still coming after me. And I got all the paperwork here showing that I had paid at that time. And it showed.
Well, it can't be from 2007 because this judgment is from 2018.
Oh, yeah, yeah. So the judgment, they were still coming after me because this account was from 2007.
But for today's purposes, the judgment's valid. I can't do anything about that. You can only object on the tax garnishment, and unless you have a legal basis, I can't sign an order on the
That's-
tax garnishment. Go ahead.
Yeah, if you may, if I may. So we did send her a dispute. She didn't respond, but I'm looking at the, on the field data sheet, it's the last page attached to the summons and complaint, and that says the account was opened. Comes from the original creditor. The account was actually opened in 2015. So I don't know.
So you're thinking of
maybe
another
confusing with another
account,
card
Miss
or something.
May.
This is Midland, right? It's from the original Sears account, right?
Give me one second. I'll tell you which. It is a Sears, but according to the creditor, the original creditor, the information provided, it says that the account open date was January 31st, 2015. Charge off was in October 2016. Last payment, $150 on April 2016. So
Yeah, but you know what? My years is all off. You're absolutely right. 2017. You got to add a one. I said 2007. Yeah. So Atlantic, it was originated with from Atlantic Financial, and I had settled with them and paid the balance off.
All right. Well, I think we sent you a dispute letter. You didn't respond. Feel free to send in anything you have that shows you had paid it off. I mean,
I got it right here. I did send it to you at that time too.
Well, can you, for today's purposes, I'm going to deny the objection because of the tax guarantee. She either owes it or not. If she has something that she can submit to you that proves that she paid it, then you can reach out to us, okay? Do you want his phone number? Can you give her your phone number?
Yeah.
Yeah, let me get a pen real quick. Okay.
586.
586.
Yep. 983. 7053.
7053.
Yep. If I have to call you back, it'll probably be a block caller ID because I'll be calling from my cell phone, but I'll leave you a message if you have voicemail.
So reach out to him and give him the paperwork, okay?
Okay, thank you.
All right, you're all set for
Thanks,
today.
Chris.
Thank you.
Yeah,
Have a
thanks.
good day.
Too.
And then Candy 13, what are you, Mr. Barras, what are you here for?
I'm here for the attorney is Sean Desai. Can you hear me?
What case are you on?
I think it's Jeremy Cady.
Oh, that case has already been disqualified. They're gonna reach out and give them another date, okay?
Okay, thank you.
Yep, you're welcome. Beaumont Health versus Deborah Borders.
Yes.
And do I have somebody from, oh, Mr. Burke, he's not back on again. So you're gonna have to just wait, Miss Borders.
Okay.
Mr. Robinson, what case are you on?
Morning,
Mr.
Judge.
Roberts, what case are you
Uh,
on?
It's Evergreen Town and Country.
You're waiting on Miss Beck?
I would assume so, Judge. Yeah.
Got it. And then, Mr. Brass, what case are you on?
Sorry, I was muted. Here for plaintiff on FCA versus James Richardson. BLK.
FCA versus James Richardson. Got it.
Thank you.
And we don't have both parties on that. And so you guys just have to wait. I'm in the middle of trying to do this motion for summary. So, but I pulled your files. All right.
Thank you, Judge.
All right. Yep. Okay, counsel. Sorry about that.
Your Honor, if I could just address the point you had raised before we took the break, is that we've got this ambiguity in the TR 52 form. That may be true, but the statute isn't ambiguous. The part of the statute we're suing the counterclaim on is 257-252I1, which grants a towing service custodian of a vehicle or both the right to recover for their fees for recovery and storage from the last titled owner of a vehicle deemed abandoned under 252A.
Well, let me stop you right there. But because how is recovery recovery seems to me to be towing. It says towing and storage. You're trying to say cleanup is recovery, and I'm not sure. I mean, is there any case law out there that addresses this?
Well, I can provide it to the court. It is an issue that has come up. I'm not going to just tell you that it hasn't, but courts have held that the recovery function, the cleanup, is included under the rights under the abandonment statute under that section. So
Mr. Fracassi?
Yes, Your Honor.
Comments about what recovery means?
Your Honor, if it's ambiguous, then, maybe that's an issue for the trier of fact. But I would like to point out to the court, though, that according to the court rules, the calculation of days, February 10th was a Sunday. So by filing our petition on the 11th, it was timely.
Was the Sunday the 20th day, Mr. Corwin?
I don't have any reason to disagree with counsel. The issue is, even with that, though, Your Honor, later on when the court reinstated the claim, there was never a motion to allow for the claim to be filed. They never took any other action after their failed attempt to file. Under their petition, they just let the order reinstating the case flow without filing a motion to clarify to allow them to file their petition, which I think they probably should have done. So now the court, I don't disagree that the court didn't accept for whatever reason. It sounds like they tried.
So, Mr. Fracassi, when you filed your objection, or however it was labeled, to the TR 52, to the fees, what happened to that objection?
I don't know, Your Honor. It went to the 23rd District Court, and it was scheduled for a hearing with the 23rd District Court. And the morning of the hearing, the judge recused himself. And then it got transferred to your court. And then plaintiff or area towing filed their motion for summary disposition. And then you granted it and you entered an order closing the case. We got our
because there was a circuit, because of the circuit case that was pending. Wasn't that part of the issue?
Well, when the circuit court transferred it to the 23rd District Court, the file got sent to the 23rd Circuit Court. And so there was an extended delay in the 23rd District Court receiving it. So when they did receive it, they did schedule a hearing, but then the judge recused himself, but he entered an order releasing our equipment back to us.
Right, which is, I had dismissed it because I thought, if my memory serves me right, I thought I dismissed it because what you were looking for was the return of the equipment, and circuit court was already dealing with that. Am I wrong?
Yeah, Your Honor, I think that what I did is I filed a motion for summary disposition with you because The only claims that plaintiffs had were the claim and delivery and conversion, stuff that didn't include the abandonment claim. And the court agreed with
I
that.
remember.
And unfortunately, I should have been more clear to say, hey, but we want our counterclaim because we're properly here. But with that said, you know, I don't disagree that Judge Slavin did release the bond that was there prior.
But if he's right that the 20 days fell on a Sunday, then he timely objected to the TR 52 and he's entitled to a hearing on the reasonableness of the fees.
I agree. If he had filed on that Monday, that would be true. You know, and if the court rejected it out of no reason.
Well, it doesn't sound like to me that if it was in front of Slavins that it was that he rejected it. It's that he didn't address it, and then it wasn't raised when we, you know, they filed, and then they also filed simultaneously or whatever on their other things that I ended up dismissing, and no one raised, and we never got to the issue of the reasonableness of the fees on the TR 52.
Right.
I think that's a problem.
Okay. I get it. I understand.
As much as I would like to get rid of this case, can't do it.
Well, Your Honor, if we could just set it for maybe a hearing, I think we have engaged in discovery ongoing, unless there's additional stuff that they
What
want.
kind of a hearing do you want me to set it for?
We would have if the court denies my motion, then we would have a hearing on essentially the reasonableness of the towing, recovery, and storage fees.
By Zoom?
Yes, that's fine. I don't have a
Mr.
problem.
Fracassi, does that work for you?
Yes, Your Honor, but you know,
I'm going to deny his motion for summary, but you're entitled to move forward on the reasonableness of the fees.
Okay, and the court will set a hearing for that?
Yes.
Okay.
Yeah.
As opposed to what?
Well, I don't know. I think we've tried everything else.
Well, Your Honor, I would just maybe Mr. Fracassi and I can work on agreeing on exhibits in advance so that we make the trial easy. So
that's fine. How much time do you need?
I think it's probably a day or 3/4 of a day. We're going to have 2 expert witnesses.
No. I meant how much time do you need between now and when can I set it?
I've got a pretty tough schedule the next 2 months, but maybe in late May. Yeah.
And then as far as that goes, and it's set for technically it's a bench trial on your counterclaim.
Right.
So is it a hearing on the counterclaim or is
that's
it
a good question. What is it really? Because it's really actually you objected, so it's really technically not a bench trial. It's really a hearing on it's like a TR 52 hearing on the reasonableness of the fees. Right?
Right.
Okay, and you think that it's got to be like 60 days out or whatever at the end of May, and you think it's a half day?
Half day would work.
Mr. Fracassi, do you agree, disagree?
I
also
agree.
join me that I wish this case would just go away.
Yes, Your Honor, we do.
What about hang on. What about May 19th at 10 o'clock?
Hold on for one moment, please.
That I have a conflict on May 19th at 10 o'clock, Your Honor. I could do the afternoon of the 19th.
Yeah, I can't. Well, what's the afternoon?
The afternoon works for me, Your Honor.
I know when you say afternoon, is that like 1?
If everything goes according to plan, it would be after 1, Your Honor.
All right, then I'll set it at 1. May 19th at 1 o'clock.
That's fine, Your Honor. Thank you.
And
Our-
Your Honor,
Yes.
if I may, because one of the issues that we've had in trying to resolve this is in your order denying the area towing's motion, would your order indicate
The order that you guys are going to stipulate to and send me, is that what you're asking?
No.
Yeah. You're going to send me a stipulated that I denied your motion for summary and set it for a hearing on the TR 52 motion on May
And
the
that-
19th.
And that order will include that the conduct of Annette Holdings was not frivolous?
Oh, yeah, there's no finding that it was frivolous. Well,
Thank you.
Yeah, no.
Thank you, Your Honor.
All right.
Okay, thank you, Your Honor.
Thank you.
We'll
All
send
right,
this-
thanks.
I appreciate it.
Yep, you're all set. Thank you. Now, Mr. Barras, do we have anybody on your case, which is the FCA Holdings, James Richardson?
I don't know.
No. Well, it was set at, it's not set, it was set at 11:15, so we're a little bit, Anita Barnes, what case are you on?
Trilogy Apartments. I'm here.
I have it. All right, on Trilogy. Do I have anybody? Do I have Mr. Grand? No. On Trilogy. On Ivy, it says Ivy's Pad. What case are you on?
I am. Do you hear me?
Yes, I can. What case are you on?
It's the James Richardson FCA
Oh,
US.
yeah. Okay, on FCA versus James Richardson. Gotcha. Then, Mr. Brett, I do have Mr. Richardson.
Well, I'm not Richardson. It's Ivy Gregory, Your Honor. See, James Richardson was a guy who
Oh,
was
yeah,
in the truck.
you're here, but this is to you. Yep, I got it. It's you're Greg Transport or whatever,
Yes.
right? And this is
Yes, Your
set.
Honor.
Oh, this had to do with that we reset it for today on the
Yes.
date of loss and proof of insurance. Mr. Brass, have you talked to each other at all, or did you get proof of the insurance? What's the deal?
We've talked previously at the last hearing. We were not able to come to an agreement.
And Your Honor, I have proof of the insurance that I had at the time.
Did he show you proof of the insurance?
No.
I have it with me right now, Your Honor.
And that was a Progressive policy?
Yes.
And so it would, can you do a screen share to show us that it was in effect on April the 21st?
Can I just show it up? I don't think you can see it. Wait a minute, let me.
Yeah, no, we can't see it, but the problem, so what is Progressive saying on the coverage, Mr. Ivy? Or Mr. Gregory?
Yes, Your Honor, is saying we had insurance from 12/4/2015 to May 21st, 2017.
And so why was the coverage denied then?
I have no idea because
wasn't the coverage denied, Mr. Brass?
Yes, it was. And did the court receive my response to his objection along with my exhibit, which is a letter from Progressive denying the claim and saying.
Oh, there you go. Thank you.
Right. It attached to Exhibit A to our response. It says right out, and this is from Progressive, that after investigating the claim, there's no valid coverage for this incident and they will not pay the claim.
Yep, we have a letter from Progressive that's in the file that says there was no coverage and the claim's denied. So, regardless of whether, if you can get them to cover it, then you can do something. There's no, I'm not going to, set
Your Honor,
aside the default. Go ahead.
I got a question because I have coverage all the way through when the incident.
Well,
was
you have to
April
take
21st.
that up with Progressive. They filed a document that said that you don't. And so,
I'll talk to
pending that,
Progressive.
you're
Can
gonna
I ask
have
a
to
question?
talk to,
Another question too. When did they
Pardon?
file this?
it's dated. It is dated, well, this is an old document, actually, counsel. The
Because if they-
document is dated May 19th of 2017.
But it contains the loss date, which is April 21st of 2017.
I understand that. Unless subsequently he went back and they backdated a policy.
There was no coverage.
For the
on it.
moment, this is what I'm gonna do. I'm not setting aside the default. I'm gonna make motion to set aside the default denied. If you get me something in writing on letterhead from Progressive that says that that document is an error, then I will reopen the case. Do you understand?
Yeah, because I don't know where he got the document from.
From Progressive.
I don't know what time he filed it. I don't know what time he filed it or whatever, because it really don't say nothing on it. Because I had insurance the day of the accident.
But I can't take your document. I want a letter from a claims adjuster or
Okay.
from just like this letter is from a claims department saying that you had coverage on that date. Okay?
All right then. Okay. So
Then
how
we'll
can I get it to you?
reopen it. All right, you're all set for today, but I'm gonna deny it, and if we get something, I'll reopen it.
So
Your
how can
Honor,
I
it was
send it
my-
to you? Ask a question, Your Honor. How can I
Hang
send
on,
this
what,
document?
Mr. Barras?
It's my understanding that today's hearing was his objection to entry of default judgment that.
And I entered it.
Okay, so did you sign the default judgment?
I did.
All right, thank you.
Yep, you're welcome. If you get something, sir, forward it to us and I will reset it, okay?
Okay, I gotta forward it to you.
You have to bring it to the court, something from a claims adjuster at Progressive.
All right, I get that to you.
Okay, you're all set.
Thank you.
On Beaumont versus Deborah Borders.
Yes, Your Honor.
Good morning. We have Miss Borders. Do you want me to put you in a breakout room with Miss Borders, Mr. Burke?
Yes, please, Your Honor.
Miss Borders, can you hear me?
Yes.
I'm gonna stick you in a breakout room with the attorney. And so all you have to do is hit join.
Okay.
And then, Mr. Robinson, remind me, what case are you on?
I'm on Evergreen Town and Country, Judge.
Got it. Evergreen Town and Country versus Angela Beck. This matter was set at 11. It is, do I have Johnny Malone or Angela Beck? Neither party has appeared. Oh, this said it was set for a no cause of action. What's going on with this case?
No cause of action?
That's what it
I
says.
think it's supposed to be just cause, Judge. It's a just cause termination. I don't,
Yeah, well, somebody, yeah, I don't know. That's what she typed, but she obviously had it wrong.
yeah.
It's a judgment by default. And
Thank you,
so you can submit that to the court. All
Thank
right,
you.
you're all set.
Thank you, Judge.
You're welcome. And Miss Hamilton, you're with Trilogy
Yes.
and you're waiting on Mr. Grand.
Yes.
And we also have thought we had, yes, we have the Gordons here. Or Mr. Barnes and Mr. Gordon,
Yes.
correct? So we're just waiting on the attorney. And Mr. Asbach, what case are you on? Asbach? Sir, what case are you on? All right, on Martone and Daniel. Oh, well, let me do this real quick. Beaumont versus Deborah Borders. Did you talk to Miss Borders?
I did, Your Honor. We have resolved the case, I'll say almost 100%. Miss Borders is asking for 60 days to pay it in full to avoid a judgment. I have no objection to that. If you would, if you don't, if you would
I don't
consider,
have an objection. I'm gonna give you a, let's see, a May 18th date at 10:15. And so as long as you pay it by then they'll dismiss it, correct?
correct, Your Honor.
All right,
Did she get back in the room?
Yes, she's here. Is that right? Correct, Miss Borders?
Yes.
Okay, perfect. You're all set. Take care of it between now and then, please.
Thank you.
Thank you.
Mr. Asbach, what case are you on?
Morning, Judge. I am here on Integrated Properties versus Holt.
All right, and I don't have Tiffany Holt on here. From Grand and Grand, you're on the Trilogy Apartments versus Barnes and Gordon, is that correct?
That is correct.
And we have Miss Hamilton on here too. This was set for a non-payment. What's the status of this case? And do you need, I have a note that the CDC declaration was received and it was put out till today. What's the status now?
The last time we had spoken with the individuals, we were informed that they would be making regular payments. So I was just wondering if we would be able to speak with the defendants in a breakout room to see.
Yep, I'll put you all three in the breakout room.
Thank you.
And while that's going on, then I'll try to attempt to do your case, gentlemen. Melissa McGinnis versus Michelle Matuska.
Good morning, Your Honor. James Martone appearing on behalf of the plaintiff, Melissa McGinnis.
And Trevor Daniel on behalf of defendant Michelle Matuska.
And this is plaintiff's motion. Mr. Martone, if you want to start.
Sure. This is plaintiff's motion, Your Honor, for summary disposition on counts 1 and 2 of our complaint for fraud, silent fraud, misrepresentation, promissory estoppel, and count 2 being violation of Seller Disclosures Act. Your Honor, I won't belabor the facts of the case, but I just want to briefly touch base. The facts are pretty simple and undisputed. My client, Ms. McGinnis, and her husband purchased the house from Ms. Matuska in 2019. Ms. Matuska had previously lived in the home with her husband since 2010. Upon her husband's passing, or right before his passing, a quitclaim deed transferred full fee title to Ms. Matuska's name in 2018. Sometime between 2010 and 2019, a water pipe in the house burst or ruptured, as well as a hot water tank in the basement ruptured or otherwise displaced water into the basement such that it had to be replaced. When my client entered into purchase negotiations with Ms. Matuska in 2019, as part of that arrangement, a seller disclosure statement had to be provided from Ms. Matuska to my client and her husband. Of note in that seller disclosure statement was whether or not Ms. Matuska had knowledge of any plumbing issues with the property and if she had knowledge of any evidence of water in the basement. She expressly said no to both of those. My client relied, and My client and her husband relied on those representations, had an inspection performed, the typical just walk through, see if everything checks out. They didn't do an invasive inspection. They didn't do airborne sampling. They didn't cut out drywall or anything to that extent. They closed on the property. And then following the closing on the property, my client and her husband were starting to redo the basement bathroom. Upon opening up the wall cavities, they discovered all this mold, mildew, and other evidence of water damage to the property. And my client, upon seeing that those issues, reached out to Ms. Matuska via text, over cell phone text messages, and asked, had there been any issues with the plumbing? Namely, did a pipe burst? Ms. Matuska said, yes, a pipe did burst. My client also asked, was there any issues in the basement of flooding? Apparently someone had disclosed to her that there were some flooding issues. I understand for purposes of admissible evidence, those comments were hearsay, but nonetheless, my client inquired and Ms. Matuska did say, yes, the water heater displaced water into the basement and it needed to be replaced. So
But we agree that a water heater, needing to be replaced doesn't constitute a disclosure, or I guess I'm asking you if we agree, doesn't constitute as a necessary disclosure on the disclosure form. Do you understand what my question is?
I understand, Your Honor, about the hot water tank not requiring.
I mean, my hot water tank burst last year. If I signed a disclosure and tried to sell my house, I don't know that I would list it. Do you understand? I don't consider that water, a water problem in my basement. That was a hot water tank problem. And I fixed it.
And likewise with the hot water tank, but the more concerning issue, Your Honor, is the bursting of the pipe. And the reason why the bursting of the pipe is an issue is because I can understand the court's position on a hot water tank not being evidence of water in the basement. It is our contention. We would respectfully object to that interpretation, but I understand the court's position. The bigger issue, Your Honor, is it asks if there was any known plumbing issues and doesn't specify a time frame.
But let me ask you a question. If there was a plumbing issue and I fixed it, is there a known plumbing issue? No.
I respectfully, Your Honor, I would disagree because it doesn't say, has there been a known plumbing issue that was fixed? Or any time, or currently is there a plumbing issue? It says any known, which is a full spectrum of time at any time.
But if there doesn't,
and I understand what you're saying, Your Honor. If is there a leaky pipe now? No.
Well, let me ask you a question. Is there case law regarding this?
I haven't found case law, Your Honor, about the definition of any, but the issue is, Your Honor, a lot of these cases never get to this.
I understand that. I understand that.
And so it is kind of the crux of the matter of, had it been disclosed that there was a known problem at a certain point, my client would at least have done a further investigation of, hey, maybe we do have to look behind the walls. Maybe we do have to do airborne sampling. But the fact that a plumbing issue, that whether it was corrected, the kind of crux of the matter, Your Honor, is trying to say, well, we are taking your word that it was fixed. And maybe it was, maybe it wasn't. But it should be at least the buyer's opportunity to be informed that there was indeed an issue at a certain point within the seller's knowledge, regardless of.
I understand. And I read your motion. I understand your position. But my question to you is, isn't that for the trier of fact to determine whether or not the circumstances regarding her non-disclosure on the disclosure form, whether on the issue of whether it was a known problem or not, and whether it should have been listed on a form, isn't that an issue for a jury? I mean, this isn't like where it floods every year. You know what I'm saying? You have sewage coming up or whatever coming up, backing up pipes. You know what I'm saying? You have a pipe that burst and then it was fixed. And so, and if there's no case law out there, I think that we can agree that there's not a difference of opinion, but there can be multiple interpretations of what the disclosure should have been when you have something that happens like a burst pipe and you fix it, and whether that falls under the category of something that should have been on a form. At least without something else, I think that's for the trier of fact to make a determination on whether she should have put that on the form or not, and the fact that she didn't, whether or not that rises to the level of whatever else she found. Because I don't know if the pipe, you're saying there were bathroom problems, so where was this pipe that burst?
Oh, Your Honor, looks like I froze. Hold on. I'm sorry.
Yeah, you did.
The joys of.
Is it in the, was it in the bathroom, Mr. Daniel? Was it
No,
in the
it was an upstairs bathroom, not a lower level basement bathroom.
So that's, I mean, it's not even in the same area. So I think that those are relevant, that if I have a pipe that bursts on this side of the house and then you buy the house and the problems are on this side of the house and you're trying to get me to pay for this stuff because of a pipe that bursts over here. I don't know that all of these don't raise issues of fact that need to be decided, and that this just isn't right for a motion for summary, at least not at this point.
I understand what you're saying, Your Honor. I would just, for the record, I would think that disclosing that no plumbing issues, that there is no known knowledge of plumbing issues when we have text
When was the
messages
house
from
built?
I believe, Your Honor, in the 50s or 60s, but I don't have the exact.
So the past 60 years, we have to assume that there've been some plumbing issues. But what I'm saying is I'm not satisfied that this motion for summary rises to the level that there's no material fact. I just don't think that, I mean, is it possible that I think a jury or the trier of fact, if it's a bench trial, whatever, has to hear the testimony of what she did, what she didn't do, and whether it was reasonable for her to believe that or whether it's apparent that it was intentional of her leaving it off of the disclosure. Or, I mean, was this wasn't a for sale by owner? How was this house sold?
I believe the parties knew each other, and
Okay. I'm just curious if there was some, that they got a realtor involved, and I mean, on whether it's because the issue is if it's something that she was an honest mistake, I think that's for a trier of fact to make that determination.
Your Honor, if I could just respond quickly to it.
Yeah, go ahead.
The other issue is my client did not own the home when that pipe burst. So I don't believe there is any claim because of that. She didn't own the home until December of 2018. The home was sold about 6 months later in 19. So I don't believe that my client can be held responsible for an issue that happened prior to her home ownership.
If Your Honor, if I may just quickly address that, at the time she made the statement, she was the homeowner, and at the time the issues arose, she was living in the property and had knowledge. It doesn't make the seller disclosure statement contingent upon whether or not you were the fee title owner at the property. It is whether or not you had knowledge. I mean, the statute's pretty clear.
Right.
Did you know of the issue, and did you disclose it or not disclose it?
And I think there's actually a box you can check if it's like owner, non-owner occupied or whatever, if that's the case. Do you know what I'm saying?
And she did identify in the seller's disclosure statement, lived with husband since 2010, became title holder in 2018. So in the disclosure, she's admitting that she has been living in the home. Whether or not she was fee title owner is immaterial for purpose of whether or not her disclosures, whether she should be responsible for her disclosures on the statement. I understand the court's position about you believe there are material issues of fact regarding reasonableness and all. I would just direct the court, for the record, just the court's attention to the text message of saying, I knew these issues. I didn't disclose them. I don't have to disclose them. And I believe that just goes to the court's kind of contention of whether or not it was intentional, she knew of these issues and she purposely left them off.
Well, but the question still becomes, did she leave it off because obviously she didn't think she had to disclose, she didn't think that they were an issue. I mean, just because you're saying, she's not denying that she knew that it happened. She didn't think that it was applicable on the disclosure is what I take that to mean.
Right.
Because she's saying, I didn't have to disclose it. Meaning, I mean, you're signing a disclosure form that's swearing, you're the affiant that you're swearing to these things. So her statement only solidifies her position that she didn't think that it was a requirement, which means that if she didn't do it and she should have, that it was an honest mistake.
Well, and right, and if I could just say, they had a private home inspection in the plumbing section. Everything is checked exceptional. So there were no known plumbing issues. The inspector found all of the plumbing to be exceptional.
Well, yeah, but you never know till you break into the walls. I mean, that's the problem. It's easier to say, yep.
Well, but that's how they're not known. And
No,
that's
I know.
why
I understand. Well, you know what? I'm going to deny your motion for summary disposition at this point, counsel. But if once I do that, where does that put us with this case?
I believe
this
just
was
leaves us.
basically a pre-discovery SD motion. So I would request discovery so that we can move forward with that.
60 days.
Your Honor, I have a wedding that I'm officiating down in Georgia.
On a Tuesday?
No, I was going to say in the week of May, basically the week of May 17th through the 23rd. So if I could avoid that week, I'm available other weeks therein.
Yeah, that's the only date I have in May. I could give you the April 27th date, but is that enough time?
I don't think, I mean, I'm only looking for written discovery, but by the time they respond, by the time I can get it prepared and their response, that would be tight. I'm fine going to June if that works better.
I can do June the 15th at 10.
That works for me.
That works for me. Would this be a trial, Your Honor?
Well, I was going to do an adjourned pre-trial. I thought you guys were going to do discovery.
June 15th works for me at 10, Your Honor.
All right, June the 15th at 10 o'clock. All right.
Thank
do
you,
we
Your
need
Honor.
to prepare an order to?
Yes, please do.
Denying?
Please
Your Honor, for the order, are you dismissing the motion without prejudice?
Yes.
Okay.
Okay, so we simply,
Well, I'm ruling against your, I mean, you can renew the motion. It's just a denial of the motion. I'm
That's
not
what I'm saying.
dismissing it.
I'm sorry, denial without prejudice.
Yeah,
so that,
you can, if there's something that comes up and you find something in discovery, you can renew it at any time, of course.
Thank you, Your Honor.
Yeah, I was just going to do a 1 sentence order. Motion is denied for the reasons stated on the record.
Perfect. Works for me.
Okay.
All right. Have a
Thank
good
you.
day, gentlemen.
Thank you, Your Honor.
Thank you. Trilogy versus Anita Barnes.
Yes.
Morning, Your Honor. Monica Bunsel, P79738, appearing on behalf of the plaintiff.
And you had a breakout with Mr. Barnes and Miss Gordon, or Miss Barnes and Mr. Gordon. Yes.
That is
Yes.
correct. Yes.
And what there was a CDC declaration that was received. What's the status? I think there were supposed to be payments. What's going on?
So the parties have come to an agreement where we will have the defendants moving out of the premises by April 2nd of 2021, and for payment to be tendered after the move out.
Okay, and that's a consent?
That will be
Yes.
a consent judgment, yeah.
And you're in agreement with that?
Yes.
Okay, perfect. All right, go ahead and file it with us. Thank you and have a great day.
You as well.
Yep, have a wonderful day. Thanks. Mr. Wine, what case are you here on? You got to unmute yourself.
Brittany Morgan. I'm Wingate Homes versus Brittany Morgan.
Perfect. Okay, then, and this matter was set at 11:30, so I give a half-hour window on integrated property versus Tiffany Holt. That matter was set at 11:15. It's been a half hour. So counsel, for the record.
Good morning, Judge Christopher Asphalt, 53129 on behalf of the plaintiff.
And this is a judgment for possession by default.
That is correct.
All right, go ahead and submit it to us and I'll sign it, okay?
Okay, I will, Judge. Thank you.
You're welcome. You're all set. Thank you. And then Mr. Wine will just wait on your case, so just hang out. Thank you. Hey, Mr. Wine, it's been a half hour, so I'll give you a judgment by default, okay?
Okay, that'd be great. Thank you.
Judgment for possession by default. You can file it with us, all right? And I'll
Okay.
sign it.
I have to, when shall I file it?
You can mail it in or email it over and we'll take it.
That's when we want to evict him, or I need to do it for this?
You need to, this is just this is set for a default for non-payment of rent, I mean, set for a hearing for non-payment of rent.
Right.
So, and so it's a judgment for possession by default. So you're gonna sign that and then 10 day, then the writ can issue 10 days after that, okay?
Okay.
So you have to file that with us, okay?
Okay, do I have the form for that?
I don't know if you have the form for that. You can go on our website and we have the form there, the court
Oh, right,
form.
right, yeah, okay. Thank you
Okay.
very much.
You're
Yeah.
welcome. If you have any questions, reach out to my civil department, okay?
I will.
All right,
will.
have a